Kenny.
Thanks, Kerlock, and thanks for all our witnesses coming in today. This is obviously a very complex issue in regards to kind of updating legislation relating to mental health care for all our citizens. So just a couple of questions in regards to the opening statement. And I just want to get clarity really kind of on the two of the questions in relation to the statements. Under section for guiding principles in respect of children, you say in section 84, it provides for a child under the age of 16 who was capable of forming their own views to be consulted where practical. The Ombudsman for Children is of the view that where practical should be deleted. Could you clarify that kind of terminology and why that, where practical should be deleted?
I'll take that question, Deputy Kenny. Thank you for it. I suppose just briefly where we're coming from is as you'll be aware, the child's right to be heard is a fundamental principle in terms of children's rights. And the key point here is that every child has a right to be heard and to have due weight given to their views in accordance with their age and maturity. The point is where practical seems to push, it shouldn't say where practical. The point is to make it feasible. So we're not, first of all, not clear what where practical is referring to, but the problem is that what's potentially going to happen there is that it'll be barriers that are either already in place or be put in place, where it'll be possible to say we couldn't consult with this child because it wasn't practical, when actually that child has a fundamental human right to be heard. If that makes sense. So it's a qualifier that we don't think it's appropriate to have there. A right to be heard is a right to be heard, not where practicable.
Okay. So it's more terminology, really, the wording.
Well, it's terminology, but it's the implications of that terminology, because what it does, inadvertently or otherwise, is potentially restrict a child's right to be heard, place limitations on it, and that's not appropriate from a children's rights point of view. As a person, you have a right to be heard, full stop, not a right to be heard where practicable. The only limit is if you don't wish to be heard, and that's a different thing altogether. Okay,
so if it was to be replaced as in terminology, how would you word it as such?
It's about deleting where practicable. It's literally deleting those two words.
Right. Okay. Just a second clarification is in regards to the intermediate and voluntary persons. Again, just kind of for clarity's sake, and I just kind of paraphrase exactly what's in this paragraph. It says, accordingly, the idea that admission of a child under the 16 on the basis of a parental consent constitutes a voluntary admission appears to the Ombudsman to be fundamentally flawed. Why would that be fundamentally flawed? I said.
Okay, I'll take that question, Deputy Kenny, as well, briefly, and Diego may wish to elaborate further. I suppose if we referenced in our observations that we submitted to the committee before Christmas, a point made, and it's a very fundamental point made by the Law Reform Commission when it was looking at the whole area of children and consent to medical treatment a number of years ago, which is that for an admission to be voluntary, there has to be an element of voluntarism involved. So if you're a child and for whatever reason you have concerns or reservations and you don't wish to be admitted, for example, your admission in plain English is not voluntary. There's no voluntary element to it. So the idea that a parent of a child, and this is not to critique parents in any way, but the idea that we provide in law that a child who expresses a wish not to be admitted would be admitted as a voluntary person solely on the basis of the consent of their parent, we think is wrong. And that's why we're calling for that there should be a third category extended to under 16s, and that's intermediate person. And that allows for a child to be admitted on the basis of parental consent, but it gets rid of this, if you like, illusion that it's voluntary on the child's part.
Okay. Okay, sorry.
Just on a small piece on that, I think that the concept of an intermediate then also gives you better data, Deputy. I think we're moving into a situation then where we know who has consented to what, and you can see it even in the adult world. If you got voluntary and involuntary, but if you've got an intermediate, it means that they have been asked, they probably have refused, and somebody has had to force the issue to bring them into an inpatient unit. Again, that allows you in turn to create a different environment and to work on that. At the moment, we assume every child is voluntary consent into every inpatient unit, and that's not the case. So it just gives us a little bit more guidance in that regard and more respect to their voice.
Okay. I mean, I'm sure this has happened. What happens in the situation of a child under the age of 16 that has, say, an acute eating disorder? And obviously, there's a medical situation where that child, if the child does not get treatment, it will lead to that child's death because of obviously lack of food and so forth. What happens in that situation where the child of under 16 says, look, I do not want to go to that particular unit? Obviously, their parents want them to go, and the doctor under the care of the child says, well, you know, we're saying that you need to go. But what happens in circumstances where the child literally refuses to get treatment?
I suppose just in terms of what's provided for Deputy Kenny under the general scheme, I suppose in a practice sense, what you'd like to think is where a child refuses, in the first instance, seeking to understand what the reasons for that are and to see whether they can be addressed. So, for example, and I'm just speaking in hypothetical terms here, you know, allowing that there are only 4 inpatient units across the country, state-funded for inpatient units across the country, you could have a situation where a child may have to move quite far away from their family, from their community, from their friends, for example, have concerns about that. You could have a child, for example, who's frightened about the prospect of being admitted to an inpatient facility if they haven't been in one before. So there could be lots of reasons why a child might refuse, you know, that potentially could be addressed, you know, in terms of it professionally, in terms of consultation and seeking to alleviate concerns and so on. But in terms of the legislation, you'll know that one of the guiding principles there set out under Head 104 is about the best interests of the child being treated as the primary consideration. And from a children's rights point of view, the way that is supposed to operate is that when you're making a decision about what's in the best or assessing and making a decision about what's in the best interest of the child, that one of the things you do is seek to hear the views of the child on whatever decision it is you're trying to make. For example, the admission of a child to an inpatient facility. And give due weight to those views. But that's not the same thing as the child determining the decision, you know. So that if you're trying to figure out what's in the best interest of this child, you seek to hear what the child's views and wishes and preferences are, to understand those, you take those into account. But if you're charged with making a decision that's in the best interest of the child, and that's your primary thing you need to think about, that's going to guide your decision making, if that makes sense. So the guiding principles do allow for that, but one of the things we flagged, I'm sorry, I'm going a little bit off point maybe in terms of your question, but it's important from our point of view, is where there's 2 things really. From the way it's written right now, and allow it's a general scheme, it's not the actual wording of the bill, it's not clear how these principles are going to interact. Okay, so it says here's a list of principles, but it doesn't say how they relate to one another. And we think that further attention needs to be given to that. So for example, there's nothing there to suggest what I've just talked about, which from a children's rights point of view is really critical, is that when you're assessing what's in a child's best interest, hearing their views is a pivotal part of that, okay? But there's nothing under the principles to suggest that. And I suppose alongside that, that's one of the reasons we've suggested that it would be worthwhile to consider including provision in the bill, setting out what are the factors that a decision maker, whether it's a health professional or a court, needs to consider when they're making a determination about what's in the best interest of the child. We have that already in Irish law, and we referenced it under the Guardianship of Infants Act and under the Adoption Act. So there are clear factors that are laid out, a list of things you need to think about when you're deciding what's in the best interest of the child. And we think it would be very helpful for decision makers to have an equivalent list, appropriate list, provided for under this legislation.
Okay. And obviously in circumstances like that, I don't know if it's a rare circumstance, the child can be involuntary detained. I mean, that's essentially what can happen, obviously, in the best interest of the child. Even though the child could say and has the capacity to say, look, I do not want to seek treatment at all. And obviously, you know, then, the best interest of the child medically and legally then would have to involuntarily detain that child to seek treatment. It's obviously it's quite a complex issue. Just the last question in relation to those children between 16 and 18, and obviously, you know, around assisted capacity essentially means that a person of an age can make an independent decision in regards to their own health. So forth. And obviously, that's probably not the best definition. That's probably the definition that's come to me and so forth. But in relation to children between 16 and 18, what is the kind of I suppose the determination in relation to a child that has maybe in the throes of a pretty kind of dire mental health situation, and they either abscond or, you know, say, look, they don't want the treatment. You know, they're in a situation where it could be very traumatized. What happens in that situation, particularly for that age group, for that young person, where again we come back to the point where in the best interest of the child, in circumstances does that apply to that age group? That does apply to under 16.
Yeah, I think you're. It's the same situation I think you're talking about, Deputy. I mean, again, you originally used the example of the eating disorder, which is hugely traumatic and really invasive on the young person. They have their beliefs and they stick by them, and that will often mean even at your 7 stone weight, you will still not want to get help or think everything's okay. So in these circumstances, as Karen outlined there, the important thing is that we give weight to their voice, especially between 16 and 17 years of age. We give weight to their voice and listen to them, but at the same time, if it's a life or death scenario, that the best interest may override that, and maybe a situation in which we need to legally and medically take charge of that circumstance. And I think that's not going to change. But I think what hasn't happened before is that, again, that listening to the voice and the evolving capacity of the children and young people means that the next time you have to make a decision about them, it's going to be a bit easier because you've listened to them. You said, listen, I'm listening to you. However, we're still going to make this decision. But the next time we may listen and do something different. And again, that creates a sense of hope within the child. It creates a sense of being heard and being recognized as an individual. They won't like the answer, but it does create an opportunity to build those relationships stronger in the future. At the moment, all it is we're telling you you're going in. That's all there is to it. There's no more about it. But legally, we're now trying to build a legislation that ensures that their voices are heard as best as possible, based on their capacity. But it still doesn't override. If it's life or death scenarios, you expect a different. It wouldn't necessarily be the only answer, and that's the same in lots of decisions, not just in mental health or medical. Children will their voices and their views are heard, but other decisions can be made. We always say to children when we talk about children's rights, it doesn't guarantee that what you want happens, but it will be heard and they'll be explained otherwise if it goes in a different direction. Does that help, Deputy? Does that cover?
Yeah, it does, Dr. Badun. And there's just a final supplementary question to that, particularly around eating disorders. Again, I'm not sure if you can answer this. In a situation, and I'm sure that has happened to kind of adults, right? In a situation where a child is involuntarily detained, if a situation arises where the child refuses to eat, completely refuses to eat, what happens in them circumstances?
Again, I'm not very well placed on it, but my understanding from a number of cases we've heard here is that the medical and the parents will take over. You know, if there's an imminent threat to life, then the medical obligations are to retain life and to maintain life, and I presume the parents will step in and support that. That would be my understanding.